Well, you've had a couple of recent successes here in these cases that you guys have filed against, a state law and a county ordinance that dealt with, handguns in both cases. The first major ruling we got deals with Maryland's, I think they call it the handgun qualification license. Is that right?
And HQL.
Yeah, pistol purchase permit would be another way of terming it. But and federal court struck down this law as unconstitutional because it doesn't pass the historic traditions test set up in New York State Rifle and Pistol Association v. Bruin by the Supreme Court last year. Can you just give us a summary of what the ruling was?
Sure. The handgun qualification requirement in Maryland is truly onerous. Not only did you have to have your fingerprints taken, but it had to be taken only by a certified live scan vendor, of which there are very few in rural areas. It had to do 4 hours of training, but the training had to be by a state certified by the Maryland State Police instructor. You had to go to a range where you can fire one live round. In most of urban Maryland, you can't fire a live round legally except on a range. And in most of urban Maryland, there are very few ranges. So you have to find an instructor who had access to a range and pay the range fees. So you had to do all of that, pay $50 application fee, pay for the training, which it can be up around $200, then pay for the fingerprinting, which is around $75 by the time they're done with it, because that's done by a private vendor and they're free to set their own fees. And then by the time you're done, you had to wait 30 days, up to 30 days, for the Maryland State Police to approve you in order to have the license, which then would permit you to do the same thing over again. And essentially, before you can buy a gun, you would then have to submit your handgun qualification license to the FFL, who would then submit that application. It's called the 77R process, after Maryland's form. Goes back to the state police, where they do another background investigation, the same one. And you have to wait 7 days, assuming that's not disapproved, before you can pick up the handgun. So it took months to go through this process. Months. And no state other than Oregon has such a process. It is extremely burdensome. For example, there are no ranges in the city of Baltimore. So if a city resident wants to get a handgun qualification license, they would have to leave Baltimore. And that sounds like, so what? But there are a lot of people in Baltimore who don't have cars. And the hundreds of dollars of costs associated with this process basically disenfranchise the poor, or the less capable people with less means, from enjoying Second Amendment rights. Now, the court held, and I think properly so, that part of the right to keep and bear arms includes the right to acquire them in the first place. You can't bear or keep something you can't acquire. And the court held that expressly, and that seems perfectly correct. So under the first step of Bruin, that you have to see whether the text of the Second Amendment actually covers what you're complaining about, the conduct. The court clearly held, and quite correctly, that the right to acquire is indeed implicit in the text itself. And then after that, then it's simply a matter of whether or not there was an historical tradition in such kind of permission to acquire regulations that existed during the founding or anywhere in the history of the United States. And there simply isn't, and nor did the state even attempt to show it. So it was a straightforward application of the text, history, and tradition test that Bruin actually articulated, and it seems to me perfectly correct.
Yeah. There's a couple of things in there I want to dive into real quick. The first part is, I do think this is one of the first cases where I've seen a federal judge address what I've called the one weird trick that plaintiffs hate theory of Bruin, which is this idea that beyond the literal keeping and bearing parts, where owning and carrying, essentially, nothing else about firearms is protected. And you've seen this employed a couple of times. It's kind of honestly,
they tried it in this
pretty
case.
lazy
Yeah.
arguing. But I think this is the first time I've seen a federal judge actually, respond to this, and it doesn't take a whole lot of, I guess, brain power to understand that in order to keep arms, you have to be able to acquire them in some way,
Right.
and therefore he found that there are Second Amendment protections for the acquisition of firearms, right?
So this has been addressed in other cases in the context of privately made firearms.
Yeah.
And one judge has held, and other judges have held to the contrary, that there is no Second Amendment right to manufacture your own gun, even though the history of the United States is full of examples where that's how firearms were acquired. Indeed, the entire colonies were basically homemade guns being made at home or by small shops. So that really has implications elsewhere, because the acquisition doesn't mean just going to an FFL and buying one, and
Yep.
acquiring other means as well, including making one.
Yeah, I saw this also come up with Colorado recently. Their 3-day waiting period was challenged, and the federal judge in that case, the district judge there, upheld the 3-day waiting period on this idea that basically the Second Amendment doesn't protect the acquisition or sale of firearms at all.
Yeah, it's Rocky Mountain case.
Yes. So it's interesting. It's interesting to see a judge. One of the first examples that I've seen of a majority rejecting this idea and explaining why.
Well, and it's the first Court of Appeals decision to do so, but it has other applications as well. For example, the city of Chicago used to argue that there's no right to have a range in the city limits because there is a ban on keeping arms, and the Seventh Circuit has held, in fact, implicit in the right to keep and bear arms is the right to become proficient and remain proficient in their use.
Yeah, I should say post-Bruin. This has come up previously in federal courts where it's been roundly rejected. The idea that the Second Amendment doesn't apply to anything beyond keeping and bearing.
Right.
Literally.
So that's step one of Bruin. That's right. And a solid argument can be made that the right is not strictly limited to keeping and bearing arms that you already have.